from, let's say, when you joined MeitY and you started working at the Cyber Laws and Data Governance Division, to where we are now in February of 2025 with the law having been enacted in 2023, we now have a draft version of the rules that's currently undergoing public consultation. How do you think policy makers' thinking or MeitY's thinking or the government's thinking has evolved on the issue of regulating personal data in India, right?
Yeah. So first of all, principles of privacy, principle of data protection are already imbibed in the IT Act and the SPDI rules, significant sensitive personal data protection rules of 2011. So they're already there. But they were covering, one, the sensitive personal data, two, they were applicable only with respect to body corporate. So in terms of scope and in terms of, either way, the scope of data or scope of industries which are covered were limited. But this is the law which in a way has already enabled almost every company providing services in India to have a privacy policy in place. Principles of what we are seeing today in the present data protection law were already imbibed into those sections of the Act and the rules. We were also keenly observing the Puttaswamy case, which was being heard in Supreme Court, and anticipating that the privacy will be considered as a fundamental right. Government on 31st of July 2017 itself constituted an expert committee headed by Justice B. N. Shri Krishna. And that's how, in a way, a formal journey, particularly relating to privacy protection and hence protection of personal data in the digital world started. The principles, once again, are the ones, which are universal across the country. So per se, nothing much new here. But definitely some of the issues which always remained in the mind of the committee were the classification of data, the cross-border data flow, safety and privacy of children. There are also certain cases of legitimate uses by the government, and therefore, while the government has the legitimate right, particularly some functions of the government have the legitimate right to be exempted, as to what checks and balances should be made so as to ensure that everybody works within the contours of what is considered as the reasonable and right. Of course, in between there were dilemmas as to how the regulator should be empowered, how much the regulator should be empowered, what should be the policy with respect to the non-personal data, because non-personal data and personal data almost go together. There was a curious case, present data protection bill, and the present data protection act, which has finally come, is therefore has taken away the social media aspect, particularly the content-related aspects of the social media in social media. And also because there were feedback about the non-personal data, it was only one statement which was written in the 2019 bill that government realized that this is something which should be taken up in a comprehensive manner, and preferably through a different legislation or maybe through the Digital India Act amendment, which was also being considered at that time. So I do believe journey is always evolutionary, particularly in such areas which are fast changing, where requirements are changing. Fast technologies are coming fast. So it's an evolving thing. I also know that even the present act may not be fully meeting all the requirements, but that's how the ball gets rolling.